Hello, my name is Robayna-Alfonso and I work in the European Commission within the Direction General Enterprise and Industry. I am the official responsible for the new Directive 2011/7 on combating late payment in commercial transactions that was adopted on February 2011. The objective of this presentation is to illustrate the legal content of the directive, which sets up, on the one hand, a legal and business environment that support a switch to a culture of prompt payment in commercial transactions, and on the other hand, facilitate access to finance to small and medium-sized enterprises. Before explaining the novelties introduced by Directive 2011/7, I will briefly provide you with general background information. In 2000, the first directive to combat late payment in commercial transactions between businesses or between public authorities and businesses was adopted. In a nutshell, Directive 2035 does not preclude late payment in itself, but regulate its consequences, including providing adequate compensation for creditors. However, its adoption did not lead to the expected result, as an ex post evaluation confirmed. In fact, late payment in commercial transactions is still a general problem within the European Union. This problem is a serious impediment to the healthy business environment and to the functioning of the single market. Today's realities for European enterprise, notably small and medium-sized enterprise facing late payment, translate into companies going bankruptcy, more people unemployed, and less money available for R&D investment. As a result, the entire economy is negatively affected. With the objective to tackle this situation, Directive 2035 will be replaced by the more strengthened provision of Directive 2011/7. This new Directive 2011/7 is part of the Lisbon Agenda for Growth and Jobs. It implements the Small Business Act for Europe and reflects the Commission's political will to recognize the central role of SMEs in the European economy. Directive 2011/7 also contributes to the implementation of the European Economic Recovery Plan, with the willingness to improve the competitiveness of European enterprise. The new Directive of 2011 aims at improving the cash flow for European businesses, which is particularly important in time of economic downturn. It also aims at facilitating the smooth functioning of the internal market via the elimination of related barriers to cross-border commercial transactions. Directive 2011 provides creditors with instruments that enable them to fully and effectively exercise their rights when paid late, and confront public administration with measures that effectively discourage them from paying late. The directives provide for transposition by the Member States at the latest by 16 March 2013. However, the current economic context requires much earlier measures. This is why the Commission has invited and encouraged Member States to set up the effort at national level for a transposition and implementation of the new directive in 2012. Let's go now into the detail of the new provision introduced by the directive. The scope of the new Directive 2011 remains unchanged as regards Directive 2035. That means that it covers all commercial transactions between European undertakings or between European undertakings and public authorities from any European member state that leads to the delivery of goods or the provision of services for remuneration. Directive 2011 introduced an important novelty as regards payment periods. Contrary to Directive 2035, that applies the same treatment to all commercial transactions and does not harmonize payment periods, the new directive established different rules as regards payment periods, depending on the actor involved in the commercial transactions. The fundamental reason for the differentiated treatment is the different status of public authorities procuring goods and services, which is reflected in their commercial practices. While undertakings are free to choose their supplier, public authorities are bound by public procurement procedures. Indeed, the payment period is one of the negotiable items of a contract awarded by a public authority only in very exceptional cases. Therefore, and according to the new directive, in commercial transactions between businesses, enterprises will have to pay within their invoice within 60 days unless they expressly agree otherwise, and if it's not grossly unfair to the creditor. Thus, the payment period is not harmonized and the contractual party can agree on a date of the payment, providing that there is not any abuse of freedom of contract to the disadvantage of the creditor. In commercial transactions between public authorities and businesses, the payment period is harmonized for the first time. Public authorities will have to pay for goods or services that they procure within 30 days. And only in special circumstances and when expressly agreed between the contracting parties and when duly justified, public authorities may extend payment period up to a maximum of 60 calendar days. Besides, Article 4, Paragraph 4 of the new directive provides for an optional exemption to this general rule for two specific categories of public entities. Member States will have the possibility to extend the general rule of 30 days payment period to a maximum of 60 calendar days for public undertakings and public entities providing health care. It is up to each member state to decide whether to grant a longer payment period for that in any case cannot exceed 60 calendar days. In that case, member state decide to grant a longer payment period, it will have to send a report to the European Commission, which will have to make an assessment of the system by 2016. The second novelty introduced is the increase of the statutory interest rate for late payment. It will be the reference rate plus at least 8 percentage points. Let's clarify what the reference rate means. For those countries whose currency is the euro, it is the interest rate applied by the European Central Bank to its most recent main refinancing operation. For member states whose currency is not the euro, the reference rate is the equivalent rate set by its national central bank. It is also important to mention that public authorities are not allowed to fix an interest rate for late payment below the statutory interest rate. For commercial transactions between undertakings, the interest rate can be agreed upon the contractual parties. Another novelty of Directive 2011 is that enterprises will not only be automatically entitled to claim interest for late payment, but also to obtain a minimum fixed amount of €40 as a compensation for recovery costs. They can also claim for compensation for all remaining reasonable recovery costs. This could include expenses incurred inter alia in instructing a lawyer or employing a debt collection agency. As one of the main objectives of this new directive is to make it easier for SMEs to fight for their right when facing late payment, Article 7 provides businesses with more opportunities to challenge grossly unfair contractual terms and practices. This provision prohibits the abuse of freedom of contract in disadvantage of the creditor. Thus, a term in a contract or a practice relating to the date or period of payment, the rate of interest for late payment, or the compensation for recovery costs is either enforceable or give rise to claim for damage if it grossly unfair to the creditor. For example, an agreement between undertakings that expressly exclude interest for late payment will be always considered as grossly unfair. According to the directive, we should understand as grossly unfair terms or practice any contractual term or practice which grossly deviate from good commercial practice and it is contrary to the good faith and fair dealing. Under the current Directive 2035, it is not easy for SMEs to know what they could do against late payment. This will change with the new directive. A specific provision has been included to tackle the issue of transparency and awareness raising. A new Article 8 established the obligation for the Member State to publish all relevant information like the interest rate. Besides, the new directive encouraged Member States to establish prompt payment codes. Promotion campaigns or any other means to increase awareness of the remedy for late payment among undertakings are also foreseen. On this regard, the European Commission will organise an information campaign in all Member States that will start in 2012. The aim is to inform European enterprise about the new right conferred by the directive. Finally, with Directive 2011, even a small amount of interest for late payment may be charged. The current possibility under Directive 2035 to exclude claims for interest of less than €5 will be then abolished. The other European provision of Directive 2000 remain in force. Ambiguous text has been simplified and loopholes has been eliminated. Before concluding this presentation, let me clarify that these new measures are optional for enterprise insofar as they acquire the right to take actions, but they are not obliged to do so. In some circumstances, businesses may wish to extend the payment period for some days or weeks to keep its good commercial relationship with a specific client. This is not the case when dealing with commercial transactions with public authorities, as all these new measures are obligatory for public entities. They should lead by example and show their reliability and efficiency by honouring their contracts. Last but not least, Member States may continue maintaining or bringing into force laws or regulations which are more favourable to the creditor. Thank you very much for your attention.